Hello, Monica Miller here, Legal Director and Senior Counsel for the American Humanist Association. This is Legal Tuesdays, where I answer your questions about separation of church and state. The first question is from Natalie Daly, who says, Alabama just put up the 10 Commandments at the Capitol again. What can I do to get it taken down? Interestingly, I actually just saw an article, I think it was this morning, about this, and I believe that it's on private property. If it's not on private property, then we would definitely have a problem, definitely something we would challenge immediately. If it's on private property, which I think is the case, it's outside of the reach of the First Amendment, so we wouldn't challenge it. We actually have a case right now going on in Arkansas involving a newly presented 10 Commandments display on Capitol grounds, and we are challenging that as unconstitutional. The basis being that the Supreme Court's precedent makes clear that the government can't put up new monuments, new religious monuments, especially in prominent locations of government property like Capitol grounds or a courthouse. The Supreme Court did uphold one display of a 10 Commandments on Capitol grounds in Texas, but that situation was very different, where it had been put up alongside and in line with numerous other displays. It had been unchallenged for 40 years. It was old. The court basically, in a very narrow ruling, plurality, concluded that the entire setting and the context basically negated the religious aspects of the 10 Commandments. The plurality and Justice Breyer both honed in on the fact that the 10 Commandments, say unlike a Latin cross, have a dual meaning. The secular meaning tied to the foundations of lawmaking, that Moses was a lawmaker rather than just a religious leader. So the court said that in this context with 20 other, displays of similar theme and size, the reason that it was there was, some ostensible secular purpose, but basically that in totality, the secular aspects of the display predominated, and it was not seen as overly religious. On the other hand, the Supreme Court has said that a standalone 10 Commandments monument or a newer 10 Commandments monument, in the McCreary case that was decided the same day as the Van Orden decision, which was 2005 or 2005. Anyways, that a standalone one or one that's put up that's brand new is not allowed. So, and actually the Bladensburg Cross case that I argued almost exactly a year ago from, end of February last year, the import of that ruling as well, which did surround a older Latin cross, the plurality or the Justice Alito's opinion basically says that an older monument might be allowed, but reading between the lines, a newer one isn't. So all of this is to say that if it is a new monument and it is on government property, we would definitely challenge it, just like we are in Arkansas involving a brand new 10 Commandments display. So then I also saw two questions to this effect, so I'll just post one because they were almost identical. Rob Johnson asked, how is it legal to have prayer before the trial of an impeached president? I would argue it's not. What they are doing is milking a line of cases, two cases of the Supreme Court, which basically carve out a very, very narrow exception to the general rule that government prayer is not allowed. The rule is this legislative prayer exception, and it traces back to the time of our founding. And it basically said that Congress or legislatures can open up their meetings with prayer because the founders of, those who ratified our First Amendment also had paid chaplains open their legislative sessions with prayer. There are a lot of rules and constrictions on what that means. The recent Supreme Court case, Town of Grace versus Galloway, I think of 2014, basically said that if you have an open policy, a non-discriminatory policy where you let any individual layperson come in on a rotating basis, humanist, atheist, included, to give an invocation, that the government, that's allowed because it's the individual sort of the mouthpiece for those prayers. Alternatively, in the March versus Chambers ruling, the first ruling on this, it was a chaplain, so it wasn't the government itself. So there are some rules. I mean, those are just sort of two of the sort of main ones. But the short of it is that there's not actually a decision anywhere that I'm aware of that says that the legislative prayer exception can be applied to other government functions, especially with the federal government. So, for instance, if the Supreme Court wanted to start opening its sessions with a prayer, that would not be covered by the legislative prayer exception, and we would argue it's entirely inconsistent with the way in which the framers intended the First Amendment to apply. So I would argue it's definitely not legal, but it doesn't, just because something's not legal doesn't mean we can challenge it. And especially in this sort of political arena that we're in, I would not, that standing aside and who could actually have standing to challenge those prayers, I just don't see that case being a good one to bring with the way this particular Supreme Court is made up. So that's all I actually have time for today, but thank you for tuning in to Legal Tuesdays, and I look forward to speaking with you on the next segment. All right.